started in 2018 and ended in 2021. We welcome everyone as partners of this program, as participants to this program, because the success of this program was thanks to your valuable contribution as donors, as the all the partners who took part in the program. As by way of opening, we shall give the floor to the organizations that are our partners. I will introduce them briefly. The national authority, the Tunisian Bar Association, represented by Council Hassan Toukebri, on behalf of the bar, the Supreme Council Institute of Lawyering, represented by Mrs. Sihem Wasleti, the Secretary General, the Association of Young Lawyers, represented by Council Hind Fqih, and then we have the High Commission of Human Rights, UN High Commission, represented by Nidal Jordi. We apologize for the mistake in the name on the paper. We have another partner who couldn't make it today, the National Forum of Social and Economic Rights, who have another Congress of the Social Movement. The 10th and the 11th of December are the dates that are very much busy with conferences and work of associations and organizations. Without any further ado, I shall give the floor to the National Association, the Tunisian Bar Association. Mr. Hassan Toukebri, you have the floor. Good morning, everyone. Welcome. Very pleased to meet with you on the 11th of December 2000 on the concluding session of the MENA program to support legal professions and civil society. We thank all members and staff members of ILAC and all those who contributed to the success of their program, which involved all other partner organizations like the UN High Commission, the Tunisian Association of Young Lawyers, the National Forum, the Social Forum, and all those who contributed to the success of this program. This program with which we interacted with utmost endeavor to ensure its success in view of the high benefit, and I'm sure we benefited a great deal. The documents at hand confirm the interaction of many colleagues nationwide and inside the governorates of Tunisia, and the benefit was up to the training presented to them. These programs designed to provide information and knowledge about non-custodial sentences and ways of countering gender-based violence, training in social, economic, and cultural rights, the interactive platform of online learning. We firmly believe that what has been imparted is worth praising and commending. As an evidence, there was a great interaction and from the young lawyers and the elderly lawyers like myself. I wish that I hope that such programs will continue due to the great benefit reaped by everyone. I thank all of those who have supervised this program for the great benefit reaped. We are grateful for this cooperation, and we hope it will continue to progress for the welfare and for the progress of lawyers in Tunisia and everywhere. Thank you. Thank you, Council, and we thank the Tunisian Bar Association. I've mentioned some of our partners. I never mentioned our organization that is represented by Violaine Othman as member of the Advisory Council of ILAC. The floor is now handed over to Mrs. Sihem Wasleti to represent the High Institute of the Lawyering Profession. Good morning, everyone. I welcome you all. Thank you. Thanks for the invitation to the concluding session. I would like to seize the opportunity to extend my thanks to Violaine Othman, the representative of the Advisory Council of ILAC, and Mr. Salim Abdeslam, the Senior Legal Consultant in ILAC. I welcome all of the attendees. On this occasion, I wanted to reiterate the successful experience we started with the American Bar Association under the framework of the training sessions staged for the benefit of the trainers in the High Institute of Lawyers. We've had 3 successful training sessions from 2019, 20, and 21, and the topics addressed focused on gender-based violence in its first session and law number 58. The second session was designed for fair trial, and the last session was a free session focusing on the TOT programs, and after which diplomas were handed out, and these trainers became trainers in the High Institute of Lawyering. I would like to seize this opportunity to extend my thanks to all the donors of this program, especially ILAC, and I hope that all the activities will be diversified in the future with the High Institute of the Lawyering for the lawyers who are at the core of the establishment of the High Institute of Lawyering. Renewed thanks to the International Legal Assistance Consortium, and thank you very much. Thank you, Mrs. Siham Wusleti. We now hand over to the Tunisian Association of Young Lawyers, Mrs. Hind Fqih. Good morning, everyone. I'm no longer a member of the Association of Young Lawyers. I was appointed by the association to speak on its behalf. When I started the activity, I used to be a member with ILAC and with the American Bar Association. I'm the one who initiated the program. I was supervising the Committee of Training and Seminars. I'd like to thank ABA, with whom we have worked a lot in the TOT programs. The first program was with ILAC, was to train a group of lawyers, TOT programs, so that these trainers provide training sessions to the lawyers at the regional level under the framework of interactive training. And the topic pertained to liberties and rights as regards the presence of the lawyer in pre-trial investigation, and the TOT trainings we were coupled with other regional trainings. The topics of these trainings pertain to the fundamental rights, like the right to mobility, and I seize the opportunity that there are administrative judges present. The administrative tribunal advocates this right of movement and mobility, but other authorities do not enforce the decisions handed down by the administrative courts. And I hope that ILAC's programs to develop the judicial system, we can come up with solutions, because this is a great problem, and there are many fundamental rights in Tunisia that have been breached, and there are court decisions that have not been enforced. I know this is not the right place to talk about that. I was taken aback, but that's why I'm improvising. With ILAC, we worked on the interactive platform with the Tunisian Bar Association regarding e-training. On this platform, I had the pleasure to take part in creating some content for this platform. And I hope this platform will be tapped into by the lawyers so that they can so that the techniques of online and interaction could be tapped in and could be harnessed. We want to have double effects because we cannot stage in-person trainings due to COVID-19. So this platform will be the solution through the use of modern and sophisticated techniques and IT tools, how to use them in order to harness them in training. I thank you all. I thank I thank the American Bar Association, which is partner to ILAC, but I want to convey special thanks to ABA as well. Thank you all. Thank you, Mrs. Hand. Faqih, I think when you left the Association of Young Lawyers, you have been missed entirely. Everything you said was relevant, of course. Anything pertaining to rights is of interest and concern to all of us. Now the floor, now with regards to rights and liberties, we hand over to Dr. Nidal Jordi, please, on behalf of the UN High Commission for Human Rights. Good morning. As Selim has previously mentioned, the name is a bit different, but in view of what is happening in the Arab world, this multitude of names is a blessing. On behalf of the High Commission of Human Rights, we are pleased to contribute and to be present at the closing of the sessions of ILAC and all the partner associations in terms of strengthening cultural, socio-economic and cultural rights and supporting right holders, including lawyers and judges. This joint effort is the result of a long-standing cooperation between the Tunisian partners and the High Commission in order to lay down the legal and knowledge-based foundations to strengthen socio-economic and cultural rights through litigation in socio-economic and cultural rights and through the training of judges and the and those staff members working in this area, and to devise a manual and to build the capacity of right holders through civil society to demand compliance with socio-economic and cultural rights. These efforts are non-conventional efforts aimed at changing the wrong stereotypes about socio-cultural rights and concentrated the genuine understanding in keeping with the spirit of international human rights based on many issues. Compliance with socio-economic and cultural rights is the task of the states. Complying with these rights, even if it is sometimes through the gradual enforcement of rights, doesn't conceal the, does not cancel the state's obligation to fulfill and comply with these rights. Secondly, there is a number of provisions in the International Charter of Covenant of Economic, Social and Cultural Rights, like Article 3, Article 8, Article 10.3 and 13.2a, and Article 4 and Article 13.3, that all pertain to the immediate obligations of the state, like equal pay among men and women, health at the working place, fair pay, off-day holidays, protection of children, and to ensure elementary school guaranteed for everyone. Your efforts concentrated the development of the legal international rights about the state's responsibility and obligation and the other parties, even from the private sector, to consecrate these rights as part of the responsible sovereignty that considers that failure of the state would entail international responsibility, and if litigation on violations of human rights is standing before regional courts, the right holders have to be able to seek justice against those who fail to provide justice at the local level. There are many courts throughout the world proceeded to the provision of mechanisms of recourse, and there are many examples in South Africa that contributed to the enrichment of the litigation mechanism regarding socioeconomic and cultural rights. Even the goals of sustainable development are now resting on the quantitative, qualitative compliance that enables to measure the state's compliance with these rights in according with digital quantitative and qualitative standards. The High Commission of Human Rights fully understands that ending this activity doesn't mean the end of this partnership. Certainly, this will not end the commitment of the Commission to help Tunisia and ensure compliance with socioeconomic and cultural rights through the cooperation with the civil society and the government and the administrative and civil and criminal justice to comply with the rights. We shall continue to shoulder you in order to ensure consecration of human rights in Tunisia. Thank you. Thank you, Council. We now hand the floor to the representative of the Advisory Council of ILAC, Violaine. Her presentation will be in English.
Il y en a de disponibles. Okay. Okay, it's my honor today to be present with you and address you on behalf of ILAC, and primarily on behalf of Agneta Johansson, the Executive Director, and Mark Ellis, the President, who could not be here today because of the disruptions to travel in the last few weeks. We're here to recognize the achievements of a number of legal professional associations and civil society organizations through the program that was implemented with ILAC and its partner in the last 3 years. The two partners that contributed to this program are the American Bar Association and the International Bar Association, who are present with us today. As a consortium of more than 50 professional legal organizations and experts from around 30 countries around the world, ILAC and its members are committed to work together with justice sector actors to advance the rule of law and equal access to justice. Together with national partners, we seek to improve the administration of justice, increase rights protection, promote human rights education, and build bridges between institutions and civil society for justice systems that are more just, more inclusive, and more resilient. Today's event is also an opportunity to reflect on ILAC's long-standing partnership with the Tunisian legal community. Our assistance to the legal community and to the justice sector in Tunisia did not start in 2018. It started more than 10 years ago. And our first involvement in Tunisia came as a result of the long-standing relationship between the Tunisian Bar Association and the International Lawyers Union, l'Union Internationale des Avocats, who was one of ILAC's founding members. Over the years, our programming has included 2 sectoral assessments with judicial courts and with the administrative tribunal, as well as technical assistance and training that has supported the legal community, civil society, judicial courts, and the administrative tribunal. With the support of the Swedish International Development and Cooperation Agency, our programming represents more than $14 million in Tunisia and other countries of the Middle East and North Africa region. Past contributions to the Tunisian justice sector and legal community development in Tunisia have included the training of over 1,800 judges on judicial independence, the integration of human rights education methodology in the curriculum of the High Institute for Judges, and the establishment of the Tunisian Women Judges Association. Between 2018 and 2021, the program that was implemented was in continuity of these achievements, and it reflects our commitment to a fair and inclusive justice sector and a vibrant legal community in Tunisia. Implemented in collaboration with selected justice sector institutions, professional associations, and other actors in Tunisia and in Libya, the program sought to improve equal access to justice and to enhance public trust in the justice sector. Our interventions aim to assist national partners to achieve effective and timely justice for all, including those that are the most victimized by conflict, discrimination, and economic marginalization. Activities were implemented with 4 of our members. With the American Bar Association, ABA, we worked with the Bar Association, the Young Lawyers Association, and the High Institute for Lawyers to expand rights-based interactive training for legal professionals. With the International Bar Association, IBA, we worked with the administrative tribunal judges, with lawyers, and with civil society actors to enhance the justiciability of economic, social, and cultural rights. With the National Center for State Courts, NCSC, we worked with the Administrative Tribunal to improve court administration and procedural fairness. And with the Raoul Wallenberg Institute, RWI, we worked with the High Institute for Judges to create human rights education, to integrate human rights education into judicial and legal education curricula and methodologies. The program also worked with actors in the justice, legal, and civil society community in Libya to expand legal education for the public and support transitional justice efforts. In Tunisia, our interventions contributed to transformational reforms that have advanced equal access to justice and enhanced public trust in justice, especially in the administrative justice system. Our implementation approach fostered collaboration, opening space for our counterparts to develop solutions to address barriers to efficiency and accessibility. Innovation, leveraging the transformational potential of technology to introduce new digital tools. And knowledge transfers, investing in human capacity through targeted training, but especially through training of trainers, so that training could continue beyond this program. As a result of the program, we now have 2 new IT solutions that are available: an e-learning platform at the Tunisian Bar Association and a new case management system at the Administrative Tribunal that will soon enable lawyers and citizens to get direct information on their case through the website of the tribunal. We have studies indicating that 79% of administrative tribunal users report positive interaction as a result of improved communication skills that they gain through training. We have a new jurisprudence at the administrative tribunal that has expanded the protection of economic, social, and cultural rights that occurred as a result of training that was delivered to judges, lawyers, and civil society. And we count more than 800 judges and lawyers, clerks, civil society activists in Tunis, but also in Bizerte, in Nabeul, Sousse, Kairouan, Sfax, Gares, Mednin, Gafsa, Sidi Bouzid, Kasserine, Kef, and Jendouba that have participated in training organized through the program. Our program, like its predecessor between 2013 and 2016, was made possible through strong partnerships with Tunisian institutions, professional associations, and civil society organizations. Today, we convey our thanks and deepest gratitude to the Tunisian Bar Association, the Tunisian Young Lawyers Association, the High Institute for Lawyers, the High Institute for Judges, and the Tunisian Federation for Economic and Social Rights, and the 17 other civil society organizations that participated in the program. They worked tirelessly with us to implement the program and improve access to justice in Tunisia and the quality of justice outcomes for citizens. This month, our program will close, but our partnership, our friendship, and all that we have learned from each other will remain for years to come. I would also like to convey our collective thanks to CEDA for their trust and guidance over the years, and to the Swedish Embassy in Tunisia for their willingness to participate in our activities and bear witness to the work of our members and counterparts to achieve equal justice for all. Thank you, shukran.
We will now give an overview of the main achievements of this program from 2018 and 2021. We welcome both organizations that contribute to the program, in addition to the High Commission that was a partner with regards to the litigation in socio-economic and cultural rights that was implemented. We have the International Bar Association, Human Rights Institute, and we also welcome the American Bar Association that implemented the program pertaining to interactive training, and we shall give you the floor to introduce the program in more details. As regards what has been achieved during these last 3 years, we have tried throughout this program to ensure that all the judicial sectors are involved in this program. The first part focused on civil justice, administrative justice, and civil society. With regards to civilian justice, the program was about advocating rights and to use international law to advocate fragile or precarious rights. It was Raoul Wallenberg Institute that couldn't make it with us. It's about international humanitarian law. This program included 7 institutes, like the Tunisian Institute of the Judiciary, along with other 6 institutes from Morocco, Algeria, Tunisia, Palestine, Lebanon, Jordan, and Iraq. The program designed for administrative judges focused on socio-economic and cultural rights. We welcome the lawyers and judges who took part in this program, who, in their quality as trainers, and who played a key role contributing to the training of their colleagues and civil society activists in the last part of this program. For the lawyers, there were 2 programs designed for the lawyers. The program for the litigation in socio-economic and cultural rights, and the program designed for interactive training that the American Bar Association will focus on that program and introduce in more details. You will speak about the interactive platform that which stands as a permanent tool for training, so that we can use once the program is over, and which is now available to the Tunisian Bar Association. And also the civil society, the work done with the legal experts. This was a major part of the program, and the civil society benefit from this program. We noted a very good interest on part of the civil society in this program, and high demand at the end of the program to take part in the training sessions on socio-economic and cultural rights at the end of the program, because we know that the corona prevented us from presenting everything we wanted to present initially. We have achieved every component of the program, but if it wasn't for the crisis, we could have delved in more depth into these programs, and but what we have done was fruitful. And in terms of statistics, what is worth mentioning is that we have set up an interactive platform for e-learning thanks to the ABA, along with the Young Lawyers Association and the High Institute of Lawyers and the Tunisian Bar Association. We also staged 3 training programs involving 65 lawyers and a trainer from the High Institute of the lawyering profession. As regards the civil society, 22 civil society organizations and professional organizations had partaken in the ELAC program throughout the last 3 years. And among the attendees, there were lawyers from civil society activists, and we note there are 66% were women. Among them, we trained 105 lawyers and civil society activists that came from all parts of the country. And in the socio-economic and cultural rights, and also regarding the interactive training, we have trained 153 lawyers and young lawyers in particular. With regard to consolidation litigation in socio-economic and cultural rights, the first step made on this program, we have to refer to the contribution of the High Commission to this program. This program started out from the High Commission of Human Rights, and we, as ILAC, we joined this program in 2016, and this program had continued from 2018 up to 2021 in partnership with the High Commission. This partnership lasted for 5 years. This was a successful partnership. The first step was to work on the manual that was the key tool for this training, the High Commission manual, and we thank you for creating this manual because together we managed to really upgrade the content of this manual by integrating the administrative law. We focused our work on administrative law and administrative judges, and we noticed that there aren't many programs pertaining to the administrative court. Yesterday, we dedicated the entire morning session to working with the administrative court. We can only support international organizations to work with the administrative court in terms of organization and right. Throughout these 3 years, we staged 7 training programs for the trainers. That is TOT programs, trainers who have taken part in this program as judges and lawyers. The purpose behind it is to ensure that lawyers and judges become trainers of their colleagues or trainers of the components of civil society. Throughout these 7 training sessions, 44 judges and 22 lawyers have been trained in the TOT program, and overall we had 100 administrative judges and 44 lawyers. So in the practical sessions, through supervision of lawyers and judges. Regarding the civil society, we have trained 61 civil society activists throughout 5 training sessions, and the overall number of the lawyers and civil society activists amounted to 105. As regards civil society, it was at the end of the program. That is why, as you know, we were disrupted because of the health crisis. And at the beginning of this program, our fear was not to complete the program if that crisis was to linger on. That's why we staged online virtual meetings instead of the in-person trainings. And we were surprised with the outstanding success of these online sessions. We noticed a great turnout in terms of the number and in terms of the quality of the participation. That was very interesting. That prompted us to finish the program. It prompted us to achieve this program for the benefit of the civil society. We really call upon you as organizations here to work on with the civil society. There's a lot of demand. We focused on socioeconomic rights, but I imagine that you can work on other areas because there's a high demand on education and training regarding these rights. The other results noted, in addition to what we have referred to, like the interactive platform and the methodological manual, there was also development of the administrative justice that also surprised us with the speed it came with. The training of administrative judges was in 2019, before the health crisis, and it happened in easy conditions in comparison with the second cycle targeting the lawyers, when we had to face the health crisis. Moreover, the civil society in 2021, the development of administrative jurisprudence came very swiftly. At the end of 2019, some of the judges who benefit from this program applied what they have learned in their decisions, that is recourse to international law, and that would benefit the lawyers and the civil society to defend rights. We wish we could have delved more into this program, and we would have perceived recourse by the lawyers to these international instruments. The training of legal experts and the civil society, we don't have the same objectives. So the legal training was designed to improve and to consolidate legal training in order to provide legal arguments. And for the civil society, it was just at the level of awareness raising to ensure they have knowledge about their rights and awareness about their rights and the possibility to defend rights. But to lodge a lawsuit, they need consultation and advice from lawyers and those who have knowledge about these issues. As regards this topic, we can say that there's also the methodological manual for interactive training and the interactive platform already mentioned. And this platform started with three main topics, but it can be extended. This anti-gender-based violence, non-incarceration alternatives, and pre-trial detention law number 58, to which contributed the Young Lawyers Association with the American Bar Association on another program that ILAC was not involved in, because all members, partner organization with ILAC, have programs and they have independent programs. The manual was of outstanding quality and could be a reference for the legal experts and the non-legal experts, because the language was popularized and simple, and therefore the language is easy to understand. As regards interactive training, we trained 20 trainers from the High Institute of the Lawyering Profession and 153 lawyers. Young lawyers, 98 women. That accounts for 65%. It's the same percentage noted. The percentage was higher in socioeconomic rights. There were 80% women and 20% of men. For the civil society, it was about a little more than 60% for women and less than 40 for men. I need a special training to use this tool. I'm lagging behind in terms of IT technology. This program was a comprehensive program designed to integrate the highest number of participants in this program. There was a high percentage in terms of the women's participation, about 66%, as previously mentioned. It was the highest percentage of women's participation was about, with the lawyers, 80%, and that represents the new generation of lawyers and administrative judges. A remark on the participation of women and men in civil society. We noted more participation on part of women in the capital city that accounted for about 50% of the participants, or a little less than 50%, and at the regional level, the male percentage was slightly higher in the regional areas, more than the capital city. The multitude of the components of the civil society, the associations that having undergone training were specialized in public affairs, organizations advocating economic, socio-economic and cultural rights, like the Tunisian Forum for the Defense of Socio-Economic Cultural Rights. There were also associations advocating the rights of people with disabilities, and there's a high demand from these organizations on education and about rights. Environmental protection, also associations. It's no accident that these associations came from areas where the environment was aggrieved and damaged by industry, where we have a lot of industries and phosphate. Now there's a high demand on the regional level to pay attention to health conditions and environmental conditions. And from the region of Gebs, where we have chemical industries established, the other associations involved the Association for the Consumers Protection and the Child Right Association and Threatened Childhood, and along with other associations defending foreign migrants and refugees in Tunisia. As regards the geographical diversity, there was a big turnout from the south, from the capital city, good, decent turnout from the central area, but poor turnout from the north outside the capital city, Tunis. In terms of consolidating, we have come to the lessons and the possible perspectives to ensure continuity of the program, because at the end of each program, this is the issue of concern, that is to ensure sustainability, and whether this program is going to stop and everything else will stop with it. Our program unfortunately came to a draw at this point. As ILAC, we cannot coach you in the next steps in the nearest future. And this is responsibility of the organizations. What you have learned and what has been imparted has to be harnessed and used. We need to build the capacity within these associations and to transfer this knowledge and know-how within the associations. These tools should be at the disposal of those associations. There are people who have been trained and who can train their colleagues and peers. And that doesn't require huge resources. It could be done within the limits of their budgets, and they can make recourse to other donors who are focused on these issues. We also note, we can talk about the consecration of this dynamic of cooperation and exchange and innovation. by the different interactive players we've seen through the program achieved regarding socioeconomic and cultural rights. The exchange of opinion between lawyers and judges was very beneficial because the lawyer's perspective differs from those of the judges, but they managed to meet and converge on basic issues regarding the civil society. The perception of rights by the civil society was extremely important, and we noted the benefit of exchanging and interacting among these three parties. In the training of interactive training, there were some judges who are teaching at the Institute of Judges, so this will benefit also the student judges in the future. We can talk about the development of jurisprudence. Mr. Hisham Al-Hami will dwell on that later, which is not focused just on administrative jurisprudence, and even the lawyers. It could be a basis to advocate rights. It could benefit also civilian justice, even if the laws that are applied to the public and the private sector differ, but the principles shall be the same and could set the stage for the development of administrative justice, and it could also be harnessed by the civilian justice and further consolidation of rights. Last but not least, as regards the litigants, awareness raising is very important. There is high demand in this respect by the civil society for training and education. I'd like to repeat it. I cannot repeat it enough. In comparison with other countries, there's a lot of buoyancy and dynamics in the Tunisian society since 2011. And this is, it's in other countries where there is no active civil society. When we have an active civil society, this active civil society can advocate rights, and I shall hand over to Mr. Hisham later on, who says that the civil society should not be a force of anger, but it should be a force of proposal. I'm quoting you in this regard to conclude, but this would serve as a transition to dwell on that with more details about the development of administrative jurisprudence. And thank you very much.
Well, since I got the training, I started to be used to using the microphone. In the new program that we're going to embark on, we have a problem. We can't have access to the rulings. The rulings by the administrative court are not made accessible to us. It would be beneficial if those wonderful rulings handed down by the court could be accessed by us. We have another challenge with the administrative court or tribunal because actually you've worked mainly with the administrative tribunal. In most cases, the rights are lost before the ruling is handed down. You know, the period or the duration of time that the litigation takes would lead to the rights being lost. I do have a lot of respect for the administrative tribunal, but I think that we need to perhaps work more on the duration, litigation duration. Well, I know that the backlog perhaps is a real challenge, and maybe we're not using the right kind of technology with digitization, etc. So we would benefit all if all this is changed. Thank you very much, Mr. Ismail Ben Khalifa. could perhaps answer this question. Thank you very much for your question and for your suggestion. You're absolutely right in raising this issue. Concerning the deadlines, Justice Hisham will answer you. But regarding digitization, we, in the framework of the program that has just been completed with the Administrative Tribunal, we have developed a case management system, and it's going to be tied to the website of the administrative tribunal, which will make it possible to have access online for both litigants and lawyers, but also the other judges with regard to jurisprudence. So this is not a criticism, but this is a wish and a hope. And let me tell you that very, very soon your dream will become true. I would like to reassure you that a little bit of patience and we'll get there very, very soon. Thank you very much. Good morning. Welcome to all of you. I would like to probably try to provide an answer to the question by Ms. Fri. Maître Fri, um, well, the question you raised is our daily bread. Indeed, the all the efforts that we dedicate to our work throughout the entire day. And you know, sometimes while driving on the way to the tribunal, we work. Actually, this is the raison d'être of us as administrative judges. It's fair trials. We feel embarrassed and we feel shy, really, because of the delays in rendering the rulings. It is the responsibility of everyone, the state, all the governments that have been there since 2011. And also, actually, we have a wonderful jurisprudence, but this jurisprudence is obstructed by a cumbersome bureaucracy that we have inherited from the French and from the Ottomans. We still use paper as if we were in the beginning of the 20th century or late 19th century. We are about to witness a revolution that will take us to our common goal, which is a fully digitized administration that is completely dematerialized, that grants access to the litigants online. This is going to happen very, very soon. A lot of work has been done on the logistic side and on the technical side, and also on the level of training. And ILAC and NCSC have done a lot in order to get the system in place. The software is being prepared, and can you imagine that today, in the 21st century, we don't have a website as an administrative tribunal? It's a real shame and it's a real scandal. I can't, well, the word embarrassment is no longer enough to describe the situation. You know, you're absolutely true. You're absolutely correct. But, you know, at the heart of all this is the litigant. when a litigant comes to me and tells me that his case has been pending for 6 years, I can't find an answer because the litigant doesn't care. His whole life could depend on that and the issue of that particular case. But I hope that we will make that major leap forward in the near future. And also we have a new code for administrative law, and there will be a responsibility and accountability for those who fail to implement and enforce the rulings. It could be the minister who can be held to account if implementation doesn't occur. The head of government also could be held to account. Everyone at different levels could be held to account. And I think that this is going to be a very good deterrent. Mr. Hisham, Honorable Judge Hisham, we will give the floor to Yasin Athman. Yasin Athman, the floor is yours. He's going to speak on behalf of ABA. Yasin Athman from ABA, please take the floor. Athman, we'll give you the floor now, and Mr. Hami will speak later on.
As I was saying, we'd like to thank our partners in this 3-year-long program. My name is Yasin Osman. I'm a program lawyer with the International Bar Association's Human Rights Institution, responsible for managing our work in the MENA region under the auspice of which we have been involved as implementing partners in this program. I'm here with my colleague Zara Iqbal, a fellow program lawyer who has supported our work in the initial phases, and she can also contribute to our work in this important program. The IBARI, as a quick introduction, is an autonomous and financially independent entity housed with the International Bar Association, the global voice of the legal profession. Our activity is focused around working directly with the global legal community to promote and protect human rights and the independence of the legal profession worldwide. Our work ranges from human rights advocacy, trainings and technical assistance, fact-finding missions and expert reports, as well as supported directly to lawyers and judges who are arbitrarily harassed and intimidated or arrested around the world. This is to ensure enforcement of human rights and the rule of law, and the protection of democratic principles and institutions. It cannot be overstated enough how important human rights are, especially when we are living in a time where so many rights are routinely under attack, particularly economic, social, and cultural rights, which have exacerbated the plight faced by those most vulnerable in our society. It affects our standard of living, health, education, access to water. Without securing economic, social, and cultural rights, a safe and dignified life for humans cannot be achieved. Standing on equal footing with civil and political rights to form the full body of international human rights under international law. Through this program, we have understood the effective meaning of judicial enforcement and how it has a clear role in developing our understanding of ESC rights, in affording remedies in cases of clear violations, and providing decisions which can lead to systematic institutional change to prevent violations in the future. The enforcement and the monitoring of the implementation of judicial decisions often pose a challenge. However, it is up to the judiciary and to our participants, lawyers, judges, and civil society activists of this program to now demonstrate change in its differential attitude towards the executive. And in addition, civil society can play an enhanced role in monitoring implementation and demanding enforcement. This joint 3-year program realized in order for meaningful and sustainable protection and enforcement of economic, social, and cultural rights to be met, a cohesive trifecta between the judiciary, legal profession, and civil society needs to be achieved. This is to ensure a free flow of information so that violated rights are urgently prevented and remedied through the use of the law. A strong civil society enables issues to be rapidly raised with expertise in recommending appropriate paths. The legal professional is responsible for advocating on these issues through the use of the law, and the judiciary to enforce the correct and relevant standard. This program also highlighted the significance of carrying out these trainings in Tunisia, which is viewed around the globe as a beacon in the region for democracy, the rule of law, enforcement of human rights, and a healthy and strong civil society. As the birthplace of the Arab Spring, it is important to sustain and expand on the rights claimed through the Jasmine Revolution, and economic, social, and cultural rights are a part of that continuously ongoing discourse. The Ibari is grateful to have been a part of this journey, and we stand ready to support the legal profession in Tunisia and in the actual realization and implementation of this 3-year-long program. We have also been on a learning journey, identifying many cross-cutting areas for work in Tunisia, and we hope to explore this further over the coming year, expanding to work on civil and political rights as well. With thanks again to CEDA for providing funding on this program, to our colleagues at ILAC, the UNOHCHR, the American Bar Association, and NCSC, and key local partners who have contributed to this project, including the Tunisian Bar. A final thanks to Judge Hisham El-Hami for his consistent and invested role in carrying out the trainings, as well as all our trainers and participating judges, lawyers, and activists who joined and contributed to the program in order to pursue the greater realization of economic, social, and cultural rights. And to conclude, Zara and I will be around later so please do approach if you do have any questions, and thank you very much for listening. Thank you.
Thank you, Yassine.
Talk about the evolution of the administrative justice jurisprudence. I would like, first of all, to point out an important theme regarding international cooperation in Tunisia. Since 2011, we've seen the advent of many international organizations, and this was a little bit chaotic in the beginning in terms of the assistance provided. I remember this happened in 2011, 2012, and if you could remember this, Salim, everyone was working on his own, and they were perhaps duplicating their work without any coordination, and this made us miss a lot in terms of the opportunities. A lot of money has been spent without any effective outcomes. But the coordination of the work could lead to much better results. And I've seen that with ILAC and NCSC. You've worked from the same venue, and you've worked with the SIDA, with the Americans, and with the donors. The donors would be much happier with that, because they know that the money they would spend would go to the right actions and activities. Actually, our jurisprudence has evolved thanks to this kind of cooperation also. I think that this started in 2016, 2017. But as I said in the beginning, we remember that the scene was too much fragmented, actually. When we graduate from the schools of law, there are those who become lawyers, or those who become university professors, or any other any other profession that is legal in nature. Actually, in the School of Law, we were taught about the international law as if it were some kind of luxury. We've never been told that international law is an integral part of the domestic law system, because when a state ratifies an international convention, that convention becomes part and parcel of the domestic legal framework, and it's also part of the national sovereignty. This is what we got from this training, and we later on shared this knowledge with our trainees. We've learned a lot from this exchange with our international partners. We now understand that the lawyer and the judge and the civil society should think of all those legal systems in terms of that position in the national legislative or legal frameworks. We also have learned that the state has obligations which are immediate and which are gradual in the implementation of rights. And actually, now the burden of proof lies with the state and not with the litigant. The question is whether the state has actually endeavored to implement or enforce the laws. Actually, we Actually, on the occasion of this training, we've been able to get into the details of the international standards, and now we have a better understanding of the right and of the rights. Sometimes the violations of the rights are not apparent, but they are indirect. But sometimes something that is done by the state might be a serious breach of the very essence of a right. But now that we have been trained in all these areas, we have come to a better understanding and awareness of all what it takes for a right to be implemented. Since its inception, the administrative tribunal has consecrated the rights. In the beginning, the focus was on the general principles entrenched in the constitution and the legislation. But at one point, the entire judicial system has had to face the what we call the screen right. For example, if a right is not entrenched in a legislation, but it exists in the Constitution, so the judges would say that for them they wouldn't go beyond the ceiling of the law. But later on, there was a new generation of judges that have actually moved beyond this barrier. And actually, if the normal law doesn't deal with a specific right that exists in the Constitution, then we should move to the Constitution. Sometimes we refer to the Constitution, but actually we need to refer to the international conventions that have been ratified by the Tunisian state. You know the commands, for example, which could serve as a benchmark. This is something that we've learned, the general commands regarding the socioeconomic and cultural rights are binding on states, because once a state ratifies a convention, then the commands issued by the specialized committees would be binding. This has borne fruit, and today the rulings handed down by the administrative tribunal refer to all these sources. Now, let's see some of the rulings that have consecrated the socio-economic and the cultural rights after we took the training. That happened in 2019, 2020, and 2021. A key right was the right to health in general and in its details, the right to education, the right to work, the right to sporting activities, the right to family life, the right to decent housing, the right to decent life, the right to proper nutrition, the right to social security, and the right to the exercise of belief and religion. Well, actually, we've got inspiration from the international conventions and the international charter, which was ratified by Tunisia in 1969. This is broadly speaking, but let's take some rights, more specifically the right to employment. Well, we consecrated the right from the perspective of the sub-rights, for example, the right to have access to public positions, the right of the people with disabilities to have access to jobs. That is, the state has an obligation to provide for accessible work sites for people with disabilities. That's not only for Tunisians, but also the migrants, notwithstanding the fact that Tunisia has not ratified the Convention on the Rights of Foreigners, but the International Charter speaks about the right of persons or individuals and not the citizens. Here we've brought together provisions from the Constitution and the International Charter to make up for the fact that Tunisia has ratified this convention. The right to protection for the whistleblowers. This is a right that is connected to the right to employment, also the right for someone to have his degree if it is obtained from a foreign university to be approved in Tunisia within reasonable deadlines. That brings together the right to education and the right to employment, the right to assembly into unions. We actually issued a ruling whereby the government had to publish the text of the agreement with the journalist union regarding the rights of the journalists. The government did not wish to publish this agreement, but we issued a ruling to that end. The right to career advancement. Let's take another example. The right to education. The right to complete education in actually foreign universities, and the right to have a degree obtained from a foreign university accepted in Tunisia. The right to social security, the right to health, particularly in two cases, the right to good quality health on an ongoing basis, and the right to physical health and to prevention from diseases. An urgent warrant was issued so that the government can provide reparation for a person who has been incapacitated, so that he can care for his family. The right to family life also has been consecrated with respect to the foreigners, the right of the child to live with his parents, and the right to benefit from family care. The right to participate in sporting activities, the right of the athletes to take part in competitions outside the country. There was a girl who was participating in an international competition who actually, she was prevented from traveling on the grounds that she was suspected of belonging to a terrorist group. The right to practice one's religion and um, uh, the right of someone to be buried in Tunisia. Some Tunisians who were receiving training outside of the country when COVID-19 broke out were not repatriated actually after they passed away. And we issued a ruling whereby those deceased persons had to be repatriated or their corpses repatriated. Well, these are the international conventions that we've used as a benchmark. The 1966 International Charter for Socioeconomic and Cultural Rights, the Universal Declaration of Human Rights, the African Charter on Human Rights and the Rights of People, Articles 12, 13, 18, and 27 pertaining to the rights of children and family reuniting. This African Charter is absolutely rich in this regard. The UN Convention on the Rights of Children, Articles 2, 7, 8, 9, 10, and 20. You may want to refer to them. They consecrate many rights, in particular for persons with disabilities, with respect to employment and integration. The UN Convention against Corruption, Article 6, 7, 13, 32, and 33. The General Recommendation number 30 of 2004 of the UN Human Rights Council, General Command number 13 of 1999 from the UN Committee or Commission of Human Rights, the General Command number 18 of 2005 on the standards for the right to work, and the Charter of Basic Rights of the EU of the year 2000. We used article number 41. That's about due diligence, particularly regarding degrees obtained from foreign universities. Well, if we sum up the rulings handed out by the court or by the tribunal, maybe the figures are not important to you, but this is in more detail what I've mentioned. Unfortunately, we don't have a website. The right of the sick people and also people with disabilities to have access to employment, the right to prevention from diseases, and the right to be buried in the homeland. 20 April 2021, a case of for the granting of a social security card, the protection of whistleblowers, and another case regarding due diligence in processing requests for the acknowledgement of a degree obtained from a foreign university. Some of these rights have been consecrated directly, but some of them were consecrated indirectly. For example, well, you know that the rights actually are interrelated, and sometimes you cannot dissociate one right from the other. For example, some of the rights cannot be enjoyed or exercised if you cannot travel, for example. And sometimes we are witnessing, more and more rulings which state very loudly the right of people to these rights. In May 2090, a person was deprived of traveling, and thus he lost his enrollment in a foreign university. And you see here the right to movement and the right to education or the right to health could be tightly intertwined. And well, as you can see, this is a long list of rulings. In July 2019, there was a case of family reuniting for foreigners, and also the right of foreigners to invest and to work. This is a foreign person who's married to a Tunisian lady and who's been deprived of having access to Tunisia. But that person had a visa at the time, and he could legally have access to the country, but he was deprived of entering the country on suspicion of terrorism. But that person was an investor in Tunisia. And sometimes some decisions are not acceptable at all. For 2 years, he was deprived of his family and of meeting with his children. And here, actually, we refer to the international conventions, including the African Convention and the Convention on the Rights of Children, and the International Charter for Socioeconomic and Social Rights. Cultural rights. Another case regarding the right of foreigners to work in Tunisia and to practice an economic activity, the right to training and to career advancement. Actually, this is about a civil servant who was about to travel to a foreign country to get some training, and who was deprived of that right on suspicion of terrorism without any evidence. The right of athletes to take part in sporting competitions in a foreign country. These are the the rights, but we will take 3 cases more specifically. The first right is for a sick person or a person with a disability to be recruited as a public servant. There was a trainee customs officer who took 1-year training and who had a medical examination, but before the end of the year, he donated blood, and it turned out that he had hepatitis B, and actually he came to the administrative tribunal, and we asked a question to the doctors about whether the disease he had could represent a threat to the people he would be dealing with. So the medical report said that the only places where that person couldn't maybe be employed is the blood donation or blood transfer centers, because other people wouldn't be contaminated directly if he works in a particular place. So he asked for he asked for some reparation and compensation, and he was a ruling was issued whereby he returned to his work. Another case. Well, actually, this was about the right not to be discriminated against in case of sickness. Even if a person is sick, The state has a responsibility to grant that person all the possible circumstances to be able to work as a civil servant, because there is a convention that protects that person. That person could be likened to a person with a disability, and the tribunal ruled that nothing in the Tunisian law would deprive a person from the right to be employed as a civil servant on the basis that he has hepatitis B. We actually focused on the interrelation between a broad range of rights, the violation of one leading to the violation of the others in consequence. The court decided that the court violated the right of that officer by taking a decision to dismiss him, and the ruling was issued as to the reparation or compensation. We referred to the Universal Declaration of Human Rights, paragraph 2, Article 27, the International Charter on Socioeconomic and Cultural Rights, Article 6, paragraph 2, Article 2, the right to employment, and the UN Convention on the rights of people with disabilities. If we consider that person to be a person with disability, his rights should be protected. The second ruling has to do with the right to be enrolled in a foreign university. A Tunisian student applied for the renewal of his passport, but no response was provided, which deprived him from getting the Erasmus scholarship, and the administration justified the refusal to grant a new passport by the fact that that person was a Salafist. But nothing was delivered to the court to prove that accusation. So we referred to the Charter on Socioeconomic and Cultural Rights, and the court ruled that the failure to provide any evidence by the administration as to the dangers that could arise from the traveling of that person abroad. Based on that, we annulled the decision. We referred to Article 12 of the International Charter on socioeconomic and on civil and political rights, and also Article 13 of the International Charter on Socioeconomic and Cultural Rights. The third ruling, someone came to the court and informed us that he reported on a case of corruption. So he went to his line managers, but the problem is that actions were taken in revenge. He went to INLUC, the National Authority Against Corruption, which by law should provide response within 7 days, but they issued no decision after 1 year. So he actually came to the court, but the problem is that the deadline was 10 days, but he came on the 11th day. So what we decided was that because the whistleblower was still subject to actions of revenge and to ongoing harassment, we decided that the protection of whistleblowers is a key right which ensues from the right to employment. So the right of the whistleblower to be provided with protection. Actually, the justification was that the National Authority Against Corruption, the justification was that that person referred the matter to his line managers first before coming to the National Authority. So we decided that because the administration was trying to take revenge on that person, the case was still valid, and that the deadlines wouldn't apply in that particular case in light of the legislation to protect whistleblowers. Actually, what is the essence of the law to protect whistleblowers, and what is the raison d'etre of the International Convention? It's about protecting the people who report on cases of corruption, even if the deadlines have not been strictly met. The law, the administrative tribunal said that the court should strike a balance between the requirements of the legal proceedings and the need to protect the whistleblower. So the court would not hesitate to give preeminence to the right to protect the whistleblower and to protect his right to work. So the court ruled that the decision issued overlooked provision number 49, article number 49 in the Constitution, which jeopardized the very essence of the right. And actually, we ruled that the National Anti-Corruption Authority should issue a decision to protect the whistleblower. We referred to Article 6 and 7 of the International Charter on Socio-Economic and Cultural Rights, and also Article 6, 7, 13, 32, and 33 of the UN Convention on the Fight of Corruption. Actually, the civil servant has an obligation to report on corruption, and the state has an obligation to protect the whistleblowers and to align its domestic legislation with the provisions of the UN Convention. Without regard to the deadlines, this is a summary of some of the rulings, but actually we are working on some ruling abstracts that we cannot mention today, but we have definitely evolved. Thank you very much, Justice Hisham Hami. Thank you very much. And I think that there's one question. I think Judge Haifa Bajila, but yeah, I'll give you the floor. But actually, I would like to ask a question about the case of the whistleblower. Yeah, now, if since the INLUC, that is the National Anti-Corruption Authority, is no longer operational, if someone submits a case or files a case with the administrative tribunal on the grounds that the whistleblower has been deprived of protection, what would be your response to this in the absence of the National Anti-Corruption Authority? Judge Haifa Bajila from the Administrative Tribunal, who was a trainee and trainer also. Thank you very much, Salim. I would like to speak a little bit about my experience as a judge in the Administrative Tribunal. Thank you. I became a member of the tribunal in 2013, and before that, I was a lawyer for 3 years. And I took part in a competition or a contest to become a judge in the tribunal. Well, actually, many say that in the history of the administrative tribunal, there are two phases, the pre-2011 and the post-2011. I would like to give a few answers to the issues that have been raised regarding the issuance of the rulings and their enforcement or execution. Well, as a rapporteur, I had 70 cases to deal with, and I thought that was too many for me, including that is actually this is the bureaucracy. We have a law that says that I have to refer the case, and I cannot really rule on a particular case if the case is not given back to me. So actually, there was a huge number of cases referred to the administrative tribunal. After 2011, there was a great deal of recruitment by the state in the civil service, and that gave rise to a huge number of cases. So from 70 cases, I started to deal with 500 cases, including 150 cases in relation to the injured of the revolution, which requires 150 expert reports to identify the level of disability, because we as judges, we don't know exactly about these technical matters. Later on, we actually, because we started to see that incredible number of cases assigned to judges, the tribunal asked for some new judges to be recruited, and the state responded with very, very small numbers of judges. Sometimes they would assign 10 judges or 7 judges to the court. So what happened is that the president of the tribunal would reduce the number of the judges sitting on a particular chamber because of the shortage in judges. Now we have tribunals in the regions, and 60 judges have been recruited to work in the regions, and there is a law. Actually, there's a law whereby all the cases to which the state is party should be processed in Tunis, that is headquarters. This is not a solution. So what happened is that the administrative judge has still the same number of cases. I think that, and now instead of 3 rapporteurs, we have 2 rapporteurs. Sometimes one chamber would deal with 1,500 cases, but only 2 rapporteurs are assigned to that task. The state doesn't wish to recruit because of the limitations on the budget. We actually, the law lays an obligation of us to refer the cases. The what actually what the only exception was with the election law, and we talked over the phone to the lawyers to speed up the process because the deadlines were only 3 days. The other element is that we don't have a service to type the rulings, unlike the civilian justice. Actually, the administrative judge would type in the ruling. So, you know, we're doing too many things at the same time, and there's an incredible number of cases that we're dealing with. Another issue has to do with the suspension of execution, which is assigned to the president of the tribunal. But at this, really, we are interested with this. We are interested with the suspension of the execution that we refer later on to the president. Now, regarding execution, this is a real problem, and that falls beyond the scope of our work. What we do is that we issue a real ruling on behalf of a citizen. The problem is that if that ruling is not executed, that citizen would come back to the tribunal to complain about the non-execution of the ruling. And what happens is actually in our former law or old law, the administration would be punished for not executing the ruling. So every time citizen comes back to us with a ruling that has not been executed, we issue a ruling against the administration. So actually, the the compensation is taken from the public finances, but this is nonsensical because it is the administration which refuses to execute a ruling. Yes, just a final point regarding the deadlines and the delays. A case would take 6 months to 10 years before a case is decided. I'm not trying to justify anything. This is a common responsibility between the judge and the state. And
I will hand over to Mr. Hisham. He referred to some 155 cases, 156 cases, 157 cases. But these cases did not wait for more than 1 year. The administrative judge would exhibit due diligence when there's a right pertaining to education or to health. That right gets preeminence or priority when the administrative judge cannot really delay cases of urgency, and there are also cases of rights where the administrative judge expedites disposition of these cases when they pertain to rights and liberties, striving to find a solution for other cases. I hope they can do better and provide us with more staff and human resources to help us. These cases, 120 and 130 cases dating back 2012, 13 and 14. These cases are still pending and not disposed. I shall hand over to Hudefki if you want to ask for the floor. Administrative justice and the state's responsibility as a citizen. I have three lawyers. There are three clients who would like to lodge a case for compensation because of denial justice and the loss of their rights. They are asking for redress. The administrative court and because of the state's neglect, the court of the administrative court should we should have more examinations and contests for students to choose administrative justice. There are some people who have been denied passports. If the state does not provide the compensation that I'm claiming, I will make recourse to international law to oblige the Tunisian state. So if we make recourse to international laws, that would be a scandal, because people will end up having international courts decisions that are not enforced by the Tunisian state. The state has to hire the administrative judges, and this is your role as a judge to advocate for that. With regard to training, we incited the civil society and the lawyers to have you taken part in the to lodge a case on public matters, how to lodge a common law case that would be binding for the state in order to correct and adjust its public policies. And the civil society can ally with the lawyers to lodge a case against the head of government to compel him to provide all necessary allocations to support the administrative justice, so that we can respect due delays and fair trial principles that Tunisia committed to through the ratified international conventions. So we would ask the head of government to respond. This will contribute to adjusting public policies, directing public policies, because as a country having ratified these conventions, what have you done in terms of your immediate obligations? Prove that you have provided for administrative courts, and that you have hired, and that you have done what is necessary, because the burden of proof will remain on the shoulder of the state, ensuring that it has done everything possible to consecrate administrative justice that would ensure fair trial without undue delay. And that is extremely important. We have to make the call on the public matters. This is what led to the development of rights in the United States and Great Britain, Scandinavian countries, Germany, France is a bit lagging behind. So we have to lodge cases for public law cases in order to incite the government to honor its obligations. I'd like to answer. I would like to focus on the technical aspect. It is true. I can only concur with what you said. We need to hire more staff. We have to also think about due management of the human resources available. For instance, in the program that we worked on with the administrative court, we found a system of duty card that made the Tunisian administrative court as the first administration that has this duty card. That is an effective way of managing human resources. Just to check on if we can the technical tools may have positive impacts, not only technical. The application that I referred to about file or case management would make it possible to reduce the burden of work on the clerical staff, because I want to remind that the clerical staff of training judge of the administrative courts, they have a high academic degree. Many of them have master's degree. This means that this application would help them to reduce the burden and the workload, and to reduce the simple administrative tasks that this staff would like to avoid because they want to focus on more important tasks. This will enable the presidents of chambers to harness the skills of the clerical staff to become like assistant judges to reduce the burden of judges, because the judges are overwhelmed and overburdened by tasks that are not really in their field of expertise, and therefore they need to focus on judicial works, and therefore there will be a positive, of course, effects. Hiring is important, but also due management of human resources should not be overlooked. Thank you, Ismail. We now hand over to Council Iman Swisi. Hello, everyone. I apologize for the bad voice. My intervention will be on two parts. A personal part about the itinerary that we started in 2019 up to today. I'd like to thank you all very, very much. Every time I receive a phone call with the name of Salim, I'm very happy, and I know that this call is about a rich program. I'd like to say that those who have supervised this program, this is an idea that I have that many people concur with me. There's Iman Swisi before this training and Iman Swisi afterwards, the lawyer and the human being, because this training has really touched us down deep inside. I have been practicing the lawyering profession for 17 years. Finally, I found that there is a link between what I've read, what I've studied, and the practical life. This training provided us with some kind of sensitivity. Any file I open, regardless of its nature, the antenna of the desks are triggered and refer me to the locations I need to go. For any petition of a case, there's always room for socio-economic and cultural rights. More than that, in connection with the civil society, even though I believe that I am very active in the civil society, but when you focus on a given area, I sense the richness of the civil society in Tunisia and the high maturity of the civil society. In 2011, we had chaos of civil society and that people wanted to act. Now we know that each association knows what it has to do. We as lawyers, we want to be a link between the civil society and the realm of rights that we want to achieve. This is the enlightened part, and I hope that we have been what we have received and acquired will continue to benefit everyone. The second part of my presentation is about some recommendations. As a lawyer, I go to the courts. Regarding the administrative court, quite honestly, I want to say this is the lost paradise, because through the administrative court, we can find that many rights have been denied. Immediately after the 25th of July, there's focus on the socio-economic and rights. What would the administrative tribunal do? Decisions of house arrest, travel bans. I was waiting for what the administrative court would say. As regards the recommendations, as Haifa has previously said, you are tied up and down by the provisions, but can there be an initial sorting of certain cases and to give priority for swift disposition for cases pertaining to rights and liberties, to instill a culture within the administrative tribunal? And I know in your chamber this is what's happening in order to generalize information. The second recommendation for the Tunisian Bar Association and the High Institute of Lawyering, how can I express this? I hope that in the training of lawyers. I receive new lawyers who come to my firm. They graduate from the institute with a lot of excitement, and then they bump into reality, and they tend to be on a downward trend. But with regard to the socio-economic and cultural rights, this is a moving and mobile subject that affects the cases of alimony, which may be the simplest case, up to willful killing or compensation, lodged compensation cases against the President of the Republic or the head of government. I hope that you can dedicate in your training curriculum an important part to ensure we don't want these rights to be luxury. We want to use them in all cases and to direct these lawyers to the lawyers, special expert lawyers dealing with these cases. In conclusion, I'd like to thank you very much. I hope that we can meet on more important events and on occasions that would enable us to remember that we are human beings on the general sense before being lawyers. There is some sensitivity between lawyers and judges, and the great communication with the judges we have gathered through these trainings, and we can be on the same tune, and we can really work together. So you made reference to the High Institute of the Lawyer. I'd like to thank Counsel Sweetie. Just to interact with what Mrs. Sweetie has said, we are, of course, bound by a training curriculum and by curriculum in the Institute, but to enrich training even in the bylaws regarding the training, we choose the topics, and this topic may be included among the future topics, and I personally pledge that we will integrate it. Something else to add to support what Council Swissi has said, to bring to bridge the gap between the lawyers and the judges. These training sessions have broken the ice and made us closer, and I personally, at the level of the Institute, we have trainers as judges, lawyers, and university professors, and during these training sessions there were closer ties, and there are demanding more of these sessions. This has been beneficial, of course, at all levels. Thank you, the Secretary General of the Institute. Concluding comments from Mr. Hisham about the topic I've raised at the beginning of the discussion. Just before I answer your question, as the Council has said, the socio-economic and cultural rights are always on a dynamic move. And unlike the civil and political rights that we refer to the right to election once every 5 years, and we don't deal with the right to assembly, right to free expression every day. But the socio-economic and cultural rights, as soon as we get up until we go to sleep, we are practicing these socio-economic and cultural rights. Before we set out from the home, we have to talk about decent housing and healthy housing, and once we get out of the house, we have to have decent transportation to practice the right to work, the right to education, the right to sport, or the right to health or medical treatment. Until people go to sleep, we are practicing the right to alimony. I always remember the civilian justice. You forgot an important session with the civilian judges in the south. It was under the framework of coordination between the High Commission of Human Rights and the High Institute of the Judiciary, there was a positive reaction on part of civilian judges, especially. It's true that the state could be sued before the administrative tribunal, but because of the privatization of public amenities, we have private education, private universities, private health institutions, where these rights are violated, and these people are sued before civilian justice, hence the necessity to further train civilian judges, and that's important. I come back to your question on the political authority that closed down the Anti-Corruption Commission. So how can the whistleblowers where do they go to ask for protection? Since the closing of the Anti-Corruption Commission, many people came to the office. There are whistleblowers who have found no way to make recourse at the administrative court. Where to? I want them to sue anyone who is there at the official authorities. You can sue the head of government or the president or the general commissioner in charge of state litigation. If you have been subjected to any reprisals, you can ask for compensation. This is the only recourse. Those who close down this public institution would bear responsibility. It was closed down by the executive. At the top of the executive and the general commissioner of the state litigation are the ones who bear responsibility for the order for protection and to compensate for damage sustained for non-providing protection and in due fashion. Thank you, Mr. Hisham. Thank you all for keeping your attention. We now break off for coffee, and we shall be back to present the American Bar Association's program on the interactive training and the interactive platform and the manual. Thank you very much.
our work and some of the highlights from our program. One highlight I'd like to mention, and one that's been mentioned previously, was the development and delivery of an online e-learning platform to the Bar Association, where lawyers can access from across the country training materials, legal resources, and they can view online trainings addressing very important matters, human rights matters, and other future trainings that could be developed in the future. ABA really provided 3 pilot courses that were offered on the platform. One addressed combating gender-based violence. Another one involved legal access. And the last one was alternatives to non-custodial interrogation. It is our hope that the Bar Association will use this wonderful tool, an asset, this e-learning platform, to develop many, many, many more online training opportunities that the legal profession can take advantage of. And that's our hope there. None of the work that we accomplished could have been done without the strong partnership and leadership from our local partners. It would have been impossible. So I want to extend a special heartfelt thank you to the Bar Association, the Young Lawyers Association, and to the Lawyers Training Institute. Without your leadership, without your enthusiasm, without your dedication, the success would not have occurred. And we really look forward to working with you in the future. With that, let me turn it over to Monta, who can really give you some details about our work and highlight some of our successes. So thank you.
Thank you. Hello, everyone. My name is Montasser Sliman. I'm a senior program officer within the American Bar Association. I just wanted on this opportunity to give you an overview on the program that we have provided with the funding from ILAC in association with our partners in Tunisia. Our partners mainly are the Tunisian Bar Association, the Tunisian Association of Young Lawyers, the High Institute of Lawyering. This program is to build the capacity of lawyers about the interactive training, interactive techniques. The initial duration was set at 30 months, and then it was extended in view of the COVID-19 pandemic. We added a period of time for the implementation of this program. Just wanted to give another overview about the motivation of this program. What made ILAC think about financing such a program in Tunisia? This program comes under the framework of a regional program funded by ILAC. Among the other reasons to launch this program is the limitations of certain countries to support the justice service. There have been many negotiations by experts within ILAC who found that there is a lack in terms of building the capacity of state institutions and the justice sector, and that many problems could derive from this shortcoming. There could be also, this could undermine public trust in state institutions and in the justice, and that could trigger, social commotions and probably may lead to uprisings. So such problems induced the ILAC institution to support the state and the state institutions and support the Tunisian state and to restore public trust in these institutions. Note that there are limitations in enforcing certain laws and international conventions in national jurisdictions. There are many Tunisian new laws that draw inspiration from international treaties and conventions, and there are the international treaties and conventions have not been fully implemented. This implementation was below expectation of these international treaties and conventions. Hence the idea among ILAC to be fully aware of these laws and to make proper use of them. The regional program of ILAC had multiple objectives, among which to upgrade the capacity of the institutions and institutions operating in the justice sector in the MENA region in order to discharge their tasks with a view to ensuring equality when it comes to access to justice. The American Bar Association's program comes under this framework. The capacity building program for the techniques, interactive techniques, is to build the capacity of the lawyers, ensuring ongoing training to continue legal education about topics of a legal nature. We will focus on human rights and legal aspects because among the purposes and objectives of ILAC, international treaties and to protect rights and liberties, in order to build the capacity of these lawyers to advocate rights and liberties in most appropriate fashion. When we kick-started this program, and after consultations with ILAC, we deemed it necessary to adopt a certain approach whereby we can convey and impart these skills and to make these lawyers aware of these laws in order to really mount cases properly, and how to impart those skills in a way that makes these lawyers acquire these techniques properly. And these techniques have to be new approaches that are interactive. But before that, we have to train them, train those lawyers about with modern techniques that are more effective. We also deemed it necessary to have these groups among our partners for the High Institute of the Lawyering. We have the professors in the High Institute, and they can attend to the training of the new councils about these new techniques. With regards to the Association of Young Lawyers, the same thing. We have Counsel Mohammed Bouzgarou. He is amongst us who underwent training, and Hind Fqih, who was with us, in order to ensure continuity for the training, and they became experts for the association of and the Bar Association to ensure ongoing training. Another equally important aspect about our working methodology, we wanted to focus on a human rights aspect, the right to mount a case, the right to be represented by a lawyer, to enable these lawyers to get acquainted with international laws and to ensure assimilate the new laws and to provide them with practical skills in order to carry out their task defending and advocating their clients effectively. As previously mentioned, our partners, the High Institute of the Lawyer Profession and the Tunisian Association of Young Lawyers and the Bar Association. I'd like to thank them, Mrs. Siham Musleti, for their flexibility and because that facilitated the program. Her presence was there. She is very responsive, responding to our emails in a timely fashion. We can stage meetings. She is extremely responsive. I'd like to thank you, Mrs. Siham, from the Bar Association, under the supervision of the former president of the Institute, the former director of the Institute and the current director. And I'd like to thank Mr. Hatem Ziu from the Bar Association, who has been quite forthcoming and responsive, and the other members of the Bar, Mrs. Nejla Tiriki, and the Association of Young Lawyers, the former bureau and the current bureau. My thanks go out to them, without whose contribution and without establishing that ease of communication, and thanks to their will for a successful program and to upgrade the skills of their staff, this couldn't have happened without their valuable contribution. The program that we implemented had two major components. The first is about providing basic and advanced training for the benefit of a group of professors in the High Institute of Lawyers on interactive training, and to stage a TOT session to ensure continuity for the training of new professors. This is the component. The second component is to train a group of lawyers well selected, 10 chosen by the Tunisian Association of Young Lawyers and 10 from the Tunisian Bar Association, about the techniques of interactive training. The activities of the program: initially, we had two international experts, Mrs. Barbara Barron and expert Masha Nevi. I'll start with the topic for the training of the professors of the High Institute of Lawyering. The key trainer was Barbara Barron, a lawyer and a professor of skills in the Morsdin College of the Hofstra University, New York. She has a lengthy bio and CV, and she has many other tasks and skills. The assistant trainer is Helmi Toumi, who is endowed with expertise in the techniques of interactive training. He is a Tunisian trainer and a lawyer, and that also facilitated conveyance of the content. He could understand and convey the legal information while providing training for the lawyers, which is never an easy task. He has contributed to that training. Professor Helmi Toumi, Council Helmi Toumi, was very helpful, especially during the COVID pandemic, when international experts were with us online via Zoom, and he was on site. There was coordination between USA and Tunisia while conducting that workshop. The number of the High Institute of the Lawyering, 22 councils, and the methodology adopted at initially, or the first stage of the training, during the first phase for the teaching college of the High Institute, defining the methodology by attending intensive interactive sessions, including a varied group of techniques and interactive techniques. We focused on Law 58 pertaining to the elimination of all forms of violence against women. The second stage was the same, but with more advanced training on the interactive tools, and there were more presentations for the benefit of the lawyers in order to master these skills. Therefore, they made presentations and peer work, and the work was focused more on fair trial issues and the right to be represented by a lawyer. These are the main topics. In the end, we staged a TOT session for the benefit of councils and professors in the High Institute of Lawyers last August. The first session was in April 2019. The second session was held in July 2021 and 20, and the third stage in August 2021. These are pictures of the first session. These are pictures from the second training, and this is a picture of the third, where the expert was with us online, and Mr. Helmut Toumi was there in person. And therefore, as to the feedback received from the High Institute of Lawyers, that this experience was very enriching, that provided added value for the professors and the councils regarding training techniques. Many of the professors started applying these skills in their lessons, and that also drew the attention of students, and the students are no longer recipients. They became full-fledged participants and active participants. From the High Institute of Lawyers, they reiterated their intention to adopt this methodology as a basic training methodology used in the Institute. Of course, we have to review the legislation. Of course, we are planning on that, but in Tunisia, we have to be cautious about, we have to draft laws or review certain laws to implement that. But what matters most is that the intention is there to adopt this methodology within this institute. As regards the second topic, for the benefit of lawyers from the Bar Association and the Association of Young Lawyers, the key trainer is Marshall Levy, a lawyer and a consultant in legal assistance and the head of ongoing training in a lawyering firm and director of a legal clinic in the United States of America. The assistant trainer was Helmut Toumi, and the number of participants amounted to 20, 10 from the Bar Association and 10 from the Association of Young Lawyers. At the beginning, we used the same methodology that is a basic training for these lawyers about the new tools that Mohammed was amongst us in the training, and he can testify to the role play, brainstorming, working within groups. There were so many skills that they had acquired at the beginning. They got acquainted with these tools, and they started applying them in the second session, in the advanced training, interactive training. At the third stage, we adopted another methodology. We didn't do the TOT session, but we wanted to obtain the training through these tools. So we kind of pushed them to train lawyers, and we told them that you have a huge task ahead of you, and it's never easy to provide a training for lawyers on human rights or legal topics by using tools that you are going to use for the first time on the ground of reality. And the quality of the information, the quality of the training has to be good. There's the name of ILAC, there's the reputation of all the stakeholders, the American Bar Association, and the lawyers who will be imparted. They are going to receive training on human rights issues, and they have to leave the training with a minimum level of satisfaction. And therefore, these guys were up to the task, and we supported them with the training sessions at the regional level. It was a new experience. They were not left on their own. We supported them logistically. We went with them to the regions. I'll mention some of the regions. In Gafsa, in Janduba, in Mednin, in the south of Tunisia, Sfax and Bizerte in the north. We staged these training sessions at the regional level, and these folks were up to the task, as I previously mentioned. The local trainer, Mr. Hilmi Toumi, was with there to support them in case they didn't quite assimilate or in terms of their preparation. Mr. Hilmi Toumi was there to support them academically and methodological terms, and we supported them in logistical terms. These training sessions were very successful indeed. These are the training sessions, and they focused on various human rights issues like law number 5 and the gender-based violence law and anti-trafficking, human trafficking law. We worked on these topics with ABA, at ABA, with other areas, with other targets, and we developed these programs, and we provided these curricula to the trainers. And ABA supported the trainers because the trainers focused on the training aspect, how to convey the training through interactive tools. And they used this manual that we provided them with that really saved them a lot of time. There's a group of lawyers who preferred to deal with other topics. For instance, in SFAX, we provided a training on the representation of a child in a given litigation. We haven't worked on this before, but the lawyers wanted to have a training on this topic, and this training was greatly successful. Another topic was about the right to a movement between the law and reality, and Mr. Zgaru was among those who benefited from this training. It was very interesting as a topic. We also provided an additional training for this group of lawyers on the techniques of online interactive training with Mr. Abdelkader Boudriga on a 3-day training. Each group was trained for 3 days, and they addressed many of the software applications and free online platforms that you can use to train not only at the level of video conference, but you can proceed interactively. There are you can write, you can make feedback or react. Therefore, we impart these skills to the councils to really reach the maximum number of beneficiaries. These are some pictures of these training sessions on the interactive training with the Association of Young Lawyers. I'll give you some statistics. During these training sessions, 153 lawyers took part in the 7 regions, and they took part and they attended training from lawyers who are training for the first time. The 147 lawyers made an assessment of the workshop. 95.5% of the lawyers expressed their satisfaction about the 7 regions, satisfaction about the lawyers who trained them for the first time. 70% of the lawyers expressed their satisfaction about these interactive training programs. This 70% is a very good percentage. And most importantly, 100% of the lawyers stated that they are able to apply the acquired know-how obtained in the training in their daily work, their human rights and legal aspects that help them with their daily tasks in advocating rights and liberties. We have trained 153 lawyers, an additional 20 lawyers from the association and the bar, and 193 lawyers all in all took part in the training. But we didn't settle with this number. We wanted to reach out to the highest number of lawyers to make them acquire these skills about the right to defense, how to defend their clients effectively, and to use the new legislation in their advocacies. We developed an online electronic platform in association with the Tunisian Bar Association and the aptitude company represented by Mr. Abdelkader Boudrig. And this platform, we didn't want just to reach out to 100 lawyers. We wanted to reach out to 1,000 lawyers. We did it in record times. We started, I think, the contract was signed in May, and the first meeting was in June, and from June up to the end of August, we had held steering meetings and validation stages. Maybe the design of the platform, if done by aptitude alone without any partner, it could make it within a month. But once we involve other 2 or 3 sides or parties, it could, take 1 year or more. Hence, the commitment of the bar and aptitude and the coordination with the American Bar Association. And there are experts who volunteered, like Counsel Hind Fqih and Counsel Hanan bin Mahmoud. They volunteered to provide the academic curriculum, and they underwent training how to conduct online interactive drills. They used to do interactive training, but in person. Now they plunged in the realm and their skills online and to really use them on this platform. This is by and large how we launched this platform on the 22nd of September. It was launched and we made it available to the Tunisian Bar Association. Now, as to where we stand now at the level of platform, it is between now aptitude and the Bar Association. They are exchanging emails of lawyers. There were so many requests, and many lawyers expressed their desire to undergo the training provided at the platform and to obtain diplomas. Many lawyers sent their email addresses, and there's coordination now between the Bar Association and Aptitude to kickstart these trainings. Just the last comment. We we focused on 3 major topics. The first major topic for the training, the right to be represented by a lawyer in the pre-trial investigation stage. This is the first, training where the lawyers can get to the platform and obtain a diploma that is validated by the Bar Association. The second thematic that was developed by ABA, apart from ILAC, to counter gender-based violence, Law 58. There's a practical manual for this law for the benefit of the lawyers as well as the non-custodial measures, and it is available on the platform in association with other programs, with or without ILAC. When we develop material, new training materials and manual on any legal or human rights topics, we shall contact the Bar Association to make it available to the lawyers. I would like to thank you all very much, and I now hand over to Mr. Abdelkader Boudriga, who will give us more insights about this platform. Mr. Abdelkader Boudriga, to introduce this interactive platform that Montasar has already partially presented.
Thank you, Montasar. Welcome to all of you. Yes, I would like to reiterate what Montasar said about the period of time that it took to develop the platform. So, the launch of the platform was on September the 1st, so I think it took like 6 months. So, the work that has been done was very important indeed regarding this platform for a number of reasons, including the fact that regardless of the fact that we operate in the sector of online education in Tunisia, Africa, and the Arab world, we do believe that online training is a very promising sector. Just to give you a few figures, some figures regarding the evolution of the online training market worldwide, besides the fact that around 8,000 to 9,000 lawyers are benefiting from training resources that are also of the same quality available to those lawyers who are working in major cities. You know that this is a problem in Tunisia with regard to regional disparities. In Tunisia, we have regional disparities with respect to the sharing of the national wealth, but at the same time, we have regional disparities in access to educational and training material of the same level or quality. We know that the socio-economic disparities are related to your capacities, and your capacities will depend on whether you have access to training or not. You know that the lawyer in the regions inside the country maybe do not have access to the same material and training opportunities as the lawyers who live in the Grand Tunis area. This online platform gives equal access to everyone, particularly in such a crucial area as justice. All lawyers have the right to have access to the same level of training material. This is why we consider this project to be paramount to the development of Tunisia. And I would like to thank our partners in this project in Tunisia. We have what we call the educational or pedagogical capital, including in the lawyering sector and the justice sector in Tunisia. Historically, we've been able to deliver good training since the 1990s when we created a number of institutions and companies that operate in schools and outside schools. This has led to a tradition in this particular field, and I do firmly believe that in Tunisia we have this pedagogical capital that is so important and that we might consider to be a national asset that could be exported. Just to give you one idea about this, part of the work that we do um, is related to exporting this knowledge to foreign countries, particularly in the African continent. We've cooperated with an African bank to export this knowledge to 19 countries in the continent. The value added in Tunisia is 95%. If we compare this with other sectors that receive incentives from the state, this added value is or stands at just 25%. Actually, this work belongs to the services sector, and we employ a lot of young people who are highly skilled. I would like to thank the American Bar Association for that support. I think that we only use 5 to 10% of technology that is developed elsewhere, not in Tunisia, but the brains are Tunisians. And I think that this is very important for the Tunisian economy. And it is very important that we be present in this market. We have the pedagogical capital, as I said earlier, and if we can capitalize on this, then the results will be outstanding, and we will be more strongly present in the African continent and in the Arab world. We have a competitive edge indeed because we use Arabic also. And well, with regard to English, I think that India is leading in this respect, but with respect to content in French and content in Arabic, I think we have a competitive edge because technology is quite accessible, easily accessible, but we have this capital that I've mentioned, and together with Hanan, Hind, and the other members of the team, we were able to turn some traditional or classical content into an interactive content. So instead of PowerPoint and PDF formats, we literally breathed life into that. And technology has been evolving steadily, and even the videos are interactive now. That means that a person who have access to the training will interact with the trainer. So instead of just reading a PowerPoint presentation or a PDF document, we can use artificial intelligence to produce smart videos. So we've been able to produce the first examples interacting with a virtual person, and we are very proud of this experience that we've undertaken with ABA. Actually, we could have just spent 1 month to prepare this, but this would have lacked authenticity. You know that the lawyers know best about their sector. Working with the team was absolutely outstanding, and there have been 15 persons involved in this work. and more than 600 pages of content were used to and, and transformed into an interactive content. We spent a great deal of time and we met frequently in order to come up with some good results. And for us, it is the end user who matters. At the end of the day, it is the end user, that is the lawyer, who should be satisfied and happy with the product. If it is useless for the lawyers, then the product would be to no avail. We've been very keen on user experience because this is what matters. Some figures regarding online training worldwide in 2021, the market was worth $195 million. By 2025, this figure will perhaps rise to 300 million dinars, half of which will be dedicated to the content. As I said earlier, we are strongly present on this international market, allowing 8,000 to 9,000 lawyers in Tunisia to benefit from training material that are of an outstanding quality. Of course, there are disparities worldwide. As we can see this in the map, the same economic disparities are replicated when it comes to training. If you want to bridge those gaps, then besides other things, people should be allowed to have access to online training, and the content should be aligned with the international best quality. This is our raison d'être in aptitude. We are present in the market because we would like to allow Tunisians and Africans to have access to training material that is of the same quality as in other parts of the world. I would like to thank once again our partners because they're helping us towards that end, and this is actually a common goal of ours. The platform is a platform that is accessible through a password and a username. So the password is sent to the user, and let me say that we've faced a few problems in obtaining personal information. We have a convention with the National Authority for the Protection of Personal Information, and I think that the Tunisian Bar Association also have a similar agreement, and I think that the personal information is properly protected. But to have access, we need to deliver or to provide those personal information. There are some tests that one has to pass, and then a certificate is delivered by the platform instantly, and the certificate could be printed out. There is a user manual that facilitates understanding of the process. Let me say that it takes no more than 10 to 15 minutes to become acquainted with how to use a platform. The training curricula, we have focused on three areas: fighting gender-based violence, law number 5, and non-custodial sanctions. Actually, we haven't been able to turn all this into an interactive material. The only one that we've managed to turn into interactive is law number 5. The non-interactive material is, just give a few examples, PowerPoint presentations and PDF. With regard to interactive content, the user could interact with the content, which facilitates learning. This has a cost, but I always say that there should be a business plan for the platform so that the platform becomes sustainable and viable indeed. So we need to think about enriching the content. We as a team, we've learned a lot from this experience. We have learned some aspects of the laws that we were not familiar with. For example, law number 5, whose content is theoretically quite difficult to understand. We managed to turn it into interactive content or material that is handily and readily available to the users. Even if the content is quite difficult or complex, then we can actually try to process that into some more accessible material that is interactive in nature. I would like to encourage the lawyers to have access to this law number 5 because we are absolutely proud of the work that's been done. It took us a lot of time and a lot of effort, and I would like to thank the lawyers who have volunteered to help us with this. Their contribution was very significant to the process. Well, Montasser, we would like to apologize because we were too demanding, and we don't have a demo today. But please go and have a look at this part of the platform. There's an introductory video that introduces you to the different steps. Then there are some activities that the user could perform, including quizzes and questions and a test. And if the user passes the test, then he or she can get a certificate. This is about the platform. We wanted, in agreement with the Tunisian Bar Association, we wished this platform to be up to date. We are using some the same techniques that are used worldwide in similar platforms, and the quality of the content, thanks to the joint efforts of everyone, is a quality that meets the international standards. And I dare to say this because we are absolutely proud of the techniques used in this platform, and also the quality of the content delivered online. Finally, I would like to thank the Tunisian Bar Association and also Dana Ahmed. I think he's talking about the American Bar Association, Montasar, Mark, and all the other members of the team who worked hard um, during summertime under difficult circumstances as the country witnessed major changes. I think that today we have 70 members of or in the platform. We are far from our objective, which stands at 1,000 for the time being. We are still facing some problems with the emails, etc., and also we need to improve our communication. We will sit with ABA to coordinate our communication efforts so that we allow more people to attend and have access to this platform. But this is quite normal in the beginning of any platform. And I hope that by March we will reach 500 members, and by the end of the year, we hope to have 1,000 lawyers with access to the platform, and we hope to collect their feedback also, because it's going to be very important to developing the platform in the future. Thank you, ILAG. Thank you, ABA. Thank you, Abdelkader. We will take questions and feedback from the room. Maître Mohamed Bouzgarro, Basma Soussi. Thank you very much. I would like to focus on a couple of points. First, I would like to thank ABA, which has made it possible for me to provide training in the regions. This training has been beneficial for me in terms of the new interactive training techniques. Some experts explained this very well to us. The second point, if someone here represents the High Lawyering Institute, I would like to tell you that the traditional mainstream way of teaching is something of the past today. We cannot today think about education without use of the interactive method. I was a student in 2013 at the institute when I graduated from the School of Law and went to the institute. I learned absolutely nothing because actually I graduated in private law and general law. With all the respect due to the teachers who are authorities in the field, late Mr. Sakhri was a teacher of mine, for example, but actually the way they teach is absolutely the same to as what we had at the School of Law. Well, it is very important that we leverage this cooperation with ABA to use the interactive method in America. An intern lawyer would go and plead before a court. Of course, this is not our legislation, but it is very important that we try to follow and replicate that model in Tunisia. It is very important that we change the way we educate and we train and we teach the lawyers in the Lawyering Institute, it is very important that we establish a link between all the theories that are taught and the reality on the ground, because the courts are absolutely different from what we are taught at the institute, and I hope that this cooperation and partnership with the various stakeholders, including ABA, will continue. And I do insist on changing the way we train lawyers. Thank you very much. بس ما أسوسي but Siam Muslati, who is the Secretary General of the Lawyering Institute, will respond to you. Thank you very much, Maître Bosgaro. As you mentioned, you graduated in 2013. That's 7 years ago. But I've been as a Secretary General for 4 years. What you're telling us about is something of the past. With all due respect, as you mentioned earlier, we started training our students interactively because our mission is to prepare lawyers to enter this sector. Actually, we insist on the applied part of the training besides the internships. We are not inventing anything new because all this is part of the legislation governing this activity. So the lawyers are sent to courts for internships, and also with law firms and any other relevant institutions. We organize field visits to courts and to prisons. We yeah, together with the American Bar Association, and since we started the training sessions, the professors have started to use interactive training, and this has been welcomed by the students who think that they have a role to play in the classroom. They work through real-life scenarios, so we are actually doing everything we can do in order to progress. And Mr. Rodrigue, you mentioned the platform, and through ABA, we would like to have access to this platform at the institute, and we would like to train the trainers also. You, Dr. Maître Bosgaro, you may understand that the professors teaching at the institute may show some reluctance to adopt this new technology, but we need to introduce them to this new paradigm, particularly as we go through the pandemic. We've had a lot of trouble at the Institute because of lack of access to this new technology, and I do agree with you, Maître Bosgaro. The profession of lawyership should move away from pure theory. You know that those lectures, theoretical lectures, may be something good, but they shouldn't be the main focus of all that we do at the Institute. We are rethinking the bylaws of the Institute and the internal regulations regarding training and testing. We are trying to focus more on practical training. would like to call upon the American Bar Association to help us with a training session dedicated to the trainers at the Institute. And we would like them to help us with having access to the platform. Now the floor is to... hello, everyone. I would like, first of all, to welcome you and to thank you very much for the kind of invitation. My name is Basma Swisi from the IPSA organization for the impaired, for those with sight impairment. I have two questions, and a recommendation. My first question is in relation to the platform. Regarding this platform, you mentioned the training in relation to gender-based violence. My question is about the content. Did you dedicate a section to women with disabilities and having access to law and litigation? Another question is about the platform. I know that there are plenty of people with disabilities who study law, and to have access to the platform. Well, if the have you taken into account the specific characteristics of the visually impaired people who may want to have access to the platform? And you know that in the future we will, education will move more towards the digital space. Another question, is there a chance we could integrate and engage with the civil society in a more interactive way? We in PSAR, we work with the visually impaired, but often people come to us as civil society activists to ask questions about their rights. Is there a way the civil society could interactively ask questions about the people's rights online? Have you been so yeah, Haifa Bajila has mentioned. Yeah, I'm a journalist actually, and I have a show about the problems of people with disabilities. We have, we always receive questions about the lack of trust in justice, and but the problem is that I've never been able to answer. Today I've learned a lot from you, and I've learned a lot of also from the other training sessions. Thank you very much. Thank you, Basma. Thank you very much. Okay, so would you like to answer? Yes. Now I will give an answer regarding the visually impaired. Unfortunately, accessibility for the visually impaired is not possible now, but we are working with Handicap International, and we know exactly what it takes for the platform to be accessible to the visually impaired or to people with disabilities, both on the level of the content and the techniques to enlarge the script. Sometimes also there are problems for the people with hearing impairment, and we will be working on that in the future. The possibility exists for that improvement. and there is no problem in that. Your observation and your feedback is absolutely important, and I think that we need to take into account those specific needs. Thank you very much. Regarding law number 58 and the content on law number 58, it's a law against violence against women. Actually, what we did was not a training program on this particular law, but we uploaded the manual onto the platform so that it could be accessible to lawyers. But you're absolutely right in pointing out the need to focus on the rights of women with disabilities. Maybe we could discuss this with the Tunisian Bar Association, and we could upload some content onto the platform. The platform now is in the hands of the Tunisian Bar Association, but we could discuss this with them. Thank you. Thank you, Salim. You know, I'm a little bit surprised to see that you're turning one of my dreams into reality. I think that maybe any upgrades of the platform to serve the interests of the people with disabilities. You've been talking about lawyers, but you didn't mention the judges. There's no administrative tribunal here, but we would like to see a stronger engagement with the judges regarding this program. It is funded by ILAC, and it's about building the capacities of lawyers, but there are other programs with other donors, working with the civil society and also with the judges. We are having a program on non-incarceration penalties and non-custodial measures. We are working with all the bodies representing those working in the legal framework on the legal field.
هذا ولا هذا؟ هذا. شكرا على سؤالكم، وهو سؤال جيد، وأعتقد شكرا.
Did you? Yeah, yeah. All right. So, is that on? All right. So, really good question about having a online platform, training platform for. All right. All right. Thanks for your patience. I just wanted to say it was a very good question. And of course, although within ILAC our focus was on specific training for lawyers, there's no reason why there shouldn't be a program also to do that for judges. It wouldn't be that hard. The technology is the same. It would just be, I would say, in my mind, doing a needs assessment in the judiciary to determine your priorities of trainings, where you think trainings are required, and then getting a working group together that are specialized in developing really interactive trainings, and then putting them together. If you put it on the right platform, I think we use Moodle, the Moodle platform. If you do that, it can be used on a variety of platforms that already exist in Tunisia. So I'm sure there's donor support that would support that, because why limit strengthening the knowledge and capacity of only lawyers? That's just one part of the system. We need to do the same thing for judiciary. We need to do the same thing for law clerks and judicial clerks. So capacity building is not in a vacuum. We should do it across the board. The system doesn't operate in a vacuum, and everybody needs to be operating at a very high level. And whatever educational efforts that you can put together for the judiciary, I encourage you to do that. Yeah.
Challenges for the future. Now, regarding the programs that consecrate rights, actually, no rights could be enjoyed without training and without effective institutions. All of us are aware of the importance of training, and we have listened to different perspectives on this particular topic. Improving the services is the responsibility of the institutions, and we've heard a lot from the judges of the administrative tribunals. Smaid provided some answers regarding the organization, but organization is not enough, because the financial resources and financial support are also equally important. Human resources are also important for the enjoyment of rights, but the organizational aspects are also very important. That is, the programs that focus on improving the organization or the internal organization of the institutions are paramount to the enjoyment of the rights. Regarding the exchange of experiences and expertise, the fact that the programs brought together professionals from different subsectors and the civil society means that different lenses are applied to the issues at hand, and this could improve our understanding of the challenges, and we can move together towards our common goal, which is the consecration of rights. If you look at the High Lawyering Institute, you pointed out some gaps, but things have improved actually since you graduated, and Ms. Wesleti reacted positively to your comment, and she responded positively to the suggestion by Ms. Suisi regarding teaching the socioeconomic and cultural rights. Think that this has been an extremely important exchange. If you look at what Ms. Snoussi said regarding the characteristics and specificities of people with disabilities, and the need to tailor the platform to the needs of people with disabilities. If something happens, like another outbreak of a disease, education should not stop. Today, we have seen that some generations have been deprived of the right to education, particularly those who've just started school over the last couple of years. They haven't had the same access to education as the previous generations. We have noted major gaps with the children who have just joined school because of COVID-19. And Mr. Budriga, you've highlighted the very, very clear trend towards more online education now and in the future. The suggestions of the civil society are very important, and maybe you could focus on our attention on things that we did not pay attention to in the past. On the other hand, access to education is something different. That is, in Tunisia, we haven't reached the stage where everyone could have access to the enjoyment of rights, like the right to education. This is something that's happening in Europe now. But in Tunisia, the people with disabilities, the visually impaired, the people with hearing impairment are suffering. When we speak about environmental rights, for example, in Tunisia, we did not pay attention to this until recently, but today we can see, particularly in the West, that there should always be an environmental component to the programs that are submitted or implemented. So these programs must take into account accessibility for everyone. Also, online education and online training is very important to those who find it difficult to travel or to move, because education is one of the socioeconomic rights par excellence, and no one should be deprived of access to that right. I wanted to end on this, and well, it would be great for the donors if they could continue their support. And I would like to go back to the civil society. Because the civil society, of course, the civil society has been calling for more training to be delivered to them in the fields of, in the legal fields and legal knowledge. Of course, we don't expect you to become specialized in that, but you need to have access to some basic information. Now, we would like to open new horizons for the civil society. It is the civil society that pushes for legislation to be changed. It is the advocacy of the civil society which leads to changes in legislation, and that leads to new jurisprudence. So I would like to second what you said about the civil society, and I'm absolutely sure that with the support of the civil society, we will have a new culture of human rights in Tunisia. Now, let me give the floor to Hélène for the concluding statement. Hélène, who is a member of the advisory board
Anglais ou
of
le français?
ILAC.
Anglais ou le français?
En français.
En français.
Thank you very much, Salim. I will speak in English. This has been a multicultural workshop indeed. On behalf of ILAC and IABA and IBA, I would like to thank you for having accepted to share this moment with us, whether in person or online. We have tried to look at the outcomes of the program. I would like to thank the participants and the speakers who have kindly accepted to share their experiences today. Our common program, which is headed by ILAC and implemented by ABA, IBA, and ABNY, will come to an end on the 31st of December. After 3 years, this has been a wonderful adventure in cooperation with ONAT, with the Association Tunisienne de Jeunes Avocats, the Tunisian Federation of Economic and Social Rights, and the civil society that members and that personnel. We have been able to establish this platform which will make it possible to have access to training modules in the future, and we hope that the lawyers will take advantage of this, but not only lawyers, but also other interested communities. And we hope that this is going to provide a gateway to other platforms. In spite of all the trouble that we've had because of COVID-19, we've been able to achieve a lot in terms of the training, from which 253 lawyers benefited and who have seen their capacities strengthened with respect to knowledge of socioeconomic and cultural rights. Also, we've been able to introduce some more interactive training techniques. We have seen a progress in the jurisprudence of the administrative tribunal with respect to using international law to acknowledge the justiciability of socioeconomic and cultural rights. And Salim, you've mentioned also the environmental rights. The results and outcomes and their implications have been possible only thanks to the contribution of everyone. On behalf of all the organizations, I would like to thank the following teams, the team of ILAC, Salim and his team, who have contributed to the success of this. The team of IBA, represented by its director here today, and the Martial, Barbara, Helmi, the trainers who made a significant contribution to the sharing of knowledge about the topics. And we have, as a result of that work, a pool of trainers that will disseminate this knowledge. Sarah and Iqbal and Yassine and the trainers and experts Christophe Gollet, Didier, Fatih Zaba, Adam El Abda, who was with us here yesterday, who worked with the trainers and who helped to put in place a pool of trainers on socio-economic and cultural rights. be that in relation to the Tunisian Bar Association or the Administrative Tribunal, the Tunisian Bar Association, the Higher Institute of Lawyering, the that cooperation has been absolutely paramount to the success of the program. The trainers and teachers at ISPA who shared their knowledge with an increasing number of beneficiaries. I would like to thank Mr. Al-Hani for his active participation to this training. The civil society organization interested in socio-economic and cultural rights whose work will allow access to these rights to an increasing number of beneficiaries. The international community with which we have established synergies, and particularly the Human Rights Commission. We would like to thank you for sharing this commitment to the defense and protection of human rights. I would like to thank the Embassy of Sweden for their support throughout the 3 years. And I would like to thank all the actors in the legal and judicial field. Thank you very much, and I would like to encourage you to continue to contribute to this effort, not only for the civilian justice, but also the administrative justice. Over the last 18 months, we've had a lot of interruptions, and the work has been seriously disrupted because of COVID-19. The litigant is often not well informed about the possible recourses, but a litigation, regardless of its nature, for a litigant, it affects a person's life or his liberty or his capacity to care for his family, and it is up to us from this sector who should provide accompaniment and provide an answer as quickly as possible. If we join hands, we will be able to overcome all these obstacles and to deliver. Thank you very much for attending this event today, and I hope and I look forward to more opportunities in the future. Thank you very much. Have a lovely weekend.